have today. Where I'd like to start is with the Fair Labor Standards Act. And obviously, that's not one of the four wage payment collection acts, but it's important with regard to how it interrelates with these state acts. The state acts do not provide any substantive entitlements to either the payment of wages or the provision of fringe benefits. These state wage payment collection acts provide remedies for other violations of law, mostly based on type of a breach of contract idea, that there's a contract between the employer and employee for the provision of certain benefits, the payment of a specific wage, and that doesn't occur. But then you can also have the relationship to look at state law, which obviously can provide certain substantive entitlements to pay or benefits, or to federal law. And when you look to federal law, you're probably going to first look, obviously, to the Fair Labor Standards Act. And as we'll go through it, you'll see that that's one of the more controversial areas as to whether the Fair Labor Standards Act can actually be used by these wage payment collection acts and provide its own remedy for a federal statute, which obviously has different remedies within it and obviously different procedural provisions within it than the State Wage Payment and Collection Act. So if we start with the FLSA, and we can go to the first PowerPoint, is that one thing that it's important to recognize is the FLSA is a little bit more limited than you sometimes think. There's two main provisions in it, substantive provisions or requirements with regard to employers. The first one is, I guess it's not coming up, so I'll just go through it, and if we, there we go. And as you'll see in this first PowerPoint slide, these are the two substantive requirements of the Fair Labor Standards Act. The first one, 29 U.S.C. Section 206, is that you have to pay each of your non-exempt covered employees $7.25 per hour. That's the minimum wage provision. The second substantive provision, 29 U.S.C. Section 207, is the overtime provision. That is that you have to pay, again, these are non-exempt, so what that means is they're not subject to the administrative, the executive, the professional exemption, basically those managerial employees who are paid salary. But for those hourly employees, they have to get 1.5 times their regular rate of pay for work over 40 hours. Those are the main substantive protections. And it's important to recognize the limitation then in that is that if you have a part-time employee, and I had a case probably 16, 17 years ago in federal court, a large case which dealt with delivery drivers, and you had a variety of folks who were part-time employees working 25 to 30 hours a week. They had claims there that they were basically having to work off the clock or having to work 15 minutes after the shift, and that they had already clocked out and they weren't getting paid for it. Well, they were getting paid so much because they were subject to a union agreement anyways, in over $10 an hour, that even if you added, say to 25 hours, 2 additional hours of work each week, they were still well above the $7.25 minimum wage. So there was no violation of the Fair Labor Standards Act. So what that just says, importantly, is that, it's not there to basically be a catch-all remedy for any type of hours of work that's not paid. Now, obviously, once you get to full-time employees working over 40 hours, well, even 15 minutes then is probably 15 minutes then that they would have gotten extra at an enhanced rate of 1.5 times. So those individuals will have protections. But the individuals who fall outside the 40 hours, unless basically that additional time brings them below the minimum wage requirement, there's no violation. So we start with those two, and the other point, and I think it's at the bottom of that PowerPoint slide, is this idea that it's not a general collection mechanism for wages paid. FLSA also doesn't provide any type of fringe benefits or a remedy for any fringe benefits that an employer provides. So we start with those as the two substantive provisions of the FLSA, and then we, as we move on, and since the PowerPoint's far enough away from me, I'll at least look at what I've got on the slides. But as we move on with regard to the FLSA, the question we have, most of these wage payment collection acts are basically aimed at getting wages promptly paid. So the question comes, does the Fair Labor Standards Act have any prompt pay provisions? And there really are no explicit prompt pay provisions in the Fair Labor Standards Act with regard to when you pay for minimum wages, with regard to when you pay for overtime pay. But the courts have interpreted, and there are some administrative regulations with regard to overtime pay that do deal with that, and courts have said that there is an implicit prompt pay requirement within the Fair Labor Standards Act. And actually, it's kind of a timely subject right now, the prompt pay requirement. The first time I ever, and there's a dearth of case law here, because you've got to remember this idea of minimum wage. If you get paid every 2 weeks, every semi-monthly, monthly, whatever, on a regular payday, it's probably going to be difficult to say at any one time you're not getting paid your minimum wage. Where the prompt pay requirements have really came in historically is where an employer stops paying wages. And the first case, and this when I was a younger lawyer back in the early 1990s, is that California went through a variety of budget crises. And they had a law in place where they would not pay their state employees if they didn't have a budget in place when the new fiscal year occurred, which is obviously kind of reminiscent of what we just faced on the federal level. So they went through, and at some point they even started paying IOUs to their employees. They hand them a paycheck with an IOU, which is interesting is that they claimed that the IOU actually was a negotiable instrument, and in fact banks were taking those IOUs during the period of time from employees, giving cash to them, and what happened is they got a 5% increase on the face value of the IOU once the state finally paid their budget. But a federal court judge said, no, that's not cash, it's not a negotiable instrument, it's scrip. We all know what scrip is. It was just something that your employer gives you, and the only place you're going to be able to get anything back for it is at the employer's store. And that's what a federal judge said. But what you had is you had a case, Biggs v. Wilson, that came up, and this was from the 1990 failure to pay. It was about a 2-week delay in wages. Brought a claim saying, look, the FLSA implicitly has a prompt pay requirement. We haven't been paid. We deserve damages for it. Interest with regard to those 2 weeks of time when we weren't paid, everything in the world. Went up to the Ninth Circuit. Ninth Circuit said, you were right. It's a violation of the FLSA if you don't get paid your minimum wages on the payday that it's due. Now there's where the vagueness kind of comes in the standard for basically when you look at it from a general standpoint. I mean, there was no dispute in that case. The minimum that these individuals were going to get paid on a particular payday, and they didn't get paid, and the only reason they didn't get paid was because they didn't have basically a budget in place. And the state officials thought that they were prohibited from paying them anything. So what happened is they said, no, if you don't get paid your minimum wages on that regular payday, that's a violation of the FLSA, and you employees are entitled to prejudgment interest basically for the time period that you didn't get your checks. That case, there was a claim for liquidated damages. It was just brought against the state officials, not against the employer of the state of California. The district court said, we don't think you can get those liquidated damages from these officials, although they allowed the claim to go forward, because there are certain provisions about who is the employer and individual liability. But they did allow the prejudgment interest in the case. So that kind of that's the main case. And why I say it's kind of important today is that in the last month, federal government employees have sued in the Court of Claims alleging that basically their delay in pay is a violation of the Fair Labor Standards Act. The same type of argument of Biggs v. Wilson. In there, I think what at least the initial case was, look, we had a payday from September 22nd to October 5th. From October 1st, when the time period the budget wasn't in place, to October 5th, we weren't paid those wages on October 11th. And those were wages that we were clearly due on our payday on October 11th. That's a violation of the Fair Labor Standards Act. We should get damages for that time period until we're paid. So why I kind of bring that up is, and one of the things that I've seen in the last year a couple of times is these ideas that when we have employers who basically have technological issues, say computer upgrades, things like that, particularly one with commissions, I've seen it, is that this idea is that I've seen them try to use these ideas of technological change as an excuse for not making payments under the Act. And what I want to say is there's no excuses. There's none at all, basically, for that underlying violation. Some of these statutes provide for liquidated damages. Some of them have a good faith requirement. Maybe with regard to that, and certainly you have catastrophes that occur at times where you might have that, but these statutes at least are generally a strict liability statute. If you don't pay on time, you're going to be liable for the wages. You're probably going to be liable for attorney's fees and costs. Ohio really is the only statute under its Prompt Pay Act that doesn't appear to allow attorney's fees. All the other statutes do. Fair Labor Standards Act does. So that's just important to remember. Now the other thing, and why I'm kind of focusing on the FLSA prompt pay requirement, you'll see in a minute when we talk about West Virginia law. But we'll go to the next slide, and I told you that there's case law mostly out there, but the FLSA does have, the Division of the Department of Labor, has some basically interpretive rules or regulations with regard to when overtime compensation is paid. Again, there's a certain vagueness to them. I mean, here it says you don't have to pay overtime compensation on a weekly basis, and there's nothing in the FLSA that deals with frequency of pay, whether it's a weekly, monthly, semi-monthly, nothing there. But what there is that basically it says the regular payday for that pay period, you have to pay wages. With regard to overtime pay, and as you'll see in this regulation, they're a little bit more vague. Maybe you can wait to the next period if you're not able to determine what that overtime is. But why I even say it from the start is vague is like, we'll go with Ohio and use that as an example. Ohio has a payment statute, the Prompt Pay Act that I mentioned before, that says that normally you pay 2 times a month. You pay basically by the 1st, and when you pay by the 1st, you're paying wages for basically time that was worked from the 1st to the 15th. So I'll use this word hold back, and what I mean is how far back you have to look that you can kind of, basically you can kind of look backward and say, well, I'm paying today, how far back do I have to go and pay wages? Because clearly, it's going to be difficult for me to pay wages that were accrued tomorrow, for yesterday. We'll talk about situations where employers try to do that, but I mean, the law recognizes in all these states at least that, you can have some period of holdback. With Ohio, it's a full pay period. Basically, you pay for the last pay period. You get paid on the 15th. The 15th is for the preceding second half of the month. You get paid then on the 1st. That's for the preceding first half of the month. So you have that holdback. I don't think there's anything in the FLSA language here in this regulation that would say that's not the appropriate payday. It could be 3 weeks ago for what was basically earned during that pay period based on state law. So I don't think you're ever going to get in trouble with these pay provisions under the FLSA if you comply with state law. We'll give the example of West Virginia where that may be difficult. And why don't we go then to West Virginia first, because West Virginia has the most, what I will say, the most complete law. because there's many more cases in West Virginia on wage payment collection probably than in all these other states. And it also has the most stringent law. And it starts with its stringency just where how it pays employees regular wages, is that you have to pay every 2 weeks. And again, that's the shortest frequency. No one else has a 2-week provision. Everyone else, in fact, are basically semi-monthly. Kentucky, Ohio, Pennsylvania, all are semi-monthly. They'll even, in some of the states, they even allow for the possibility of agreement or custom, or if when you were hired in Pennsylvania, you might even have a longer period of time. West Virginia, it's biweekly. Now, there is a provision that you can petition the Division of Labor for a special agreement to pay longer. Really difficult to get. You need to show a compelling good reason, basically. They're going to give notice to all your employees, going to hold a hearing. Anybody can come in and object if they think they should be paid. They want to be paid biweekly. I know that there's been a few over the years who could show a good reason, but I'll just say extraordinarily difficult to get a special agreement, and so really it's 2 weeks. The biggest problem, even bigger than the 2 weeks, is this idea it's a 5-day holdback. And again, that's the shortest holdback period. Ohio has basically a full pay period. Kentucky actually has 18 days. Pennsylvania has 14 days as a default, but basically says you can have a longer period of time by agreement. So again, up to and including the 5th day before the regular payday causes a lot of folks problems. It causes problems for another reason, because West Virginia is basically a direct deposit. They have a provision with regard to direct deposit is that it's not mandatory. The employer cannot require payment through direct deposit. So if the employee won't agree to have direct deposit, they have to get a physical check every 2 weeks, which obviously with a lot of rural locations here in the States, difficult to do, difficult then to comply with this 5-day holdback provision. So that's why what I'm going to talk about in the FLSA will at least you'll see why we'll have employers come to us with this concern. How are we going to comply with this? Overtime pay particularly, a lot of times, it's not scheduled. Management has to improve it. A lot of times it's separately submitted by the supervisor after he signs off, so a lot more difficult. Go to the next, and starting down this road to explain what you might do in West Virginia with the 5-day holdback with regard to payment purposes, we've got to kind of take a step back. It's a step that we'll deal with in all the states, but it starts basically with the liquidated damages provision. And one of the provisions we also have the most stringent liquidated damage provision, but it is actually, there's a limitation to it that we'll talk about right now. And that limitation is that you basically, the liquidated damages under our statute says that if you're not promptly paid within the time you're terminated, so basically all it deals with is the prompt pay of a terminated employee. It doesn't deal with prompt pay on a biweekly basis. So that's the one good thing basically we have from a statutory standpoint. And so we start with that, but again, it's the highest liquidated damages that we have. It's 3 times basically the unpaid amount. So it's higher than treble damages. Because look at what you have at 3 times is that you're looking at, say I have $1,000 unpaid. Well, 3 times is $3,000, so that's a total of $4,000. If you look at what the FLSA is, which is double damages, $1,000 in unpaid wages, $1,000 in liquidated damages, $2,000. So you start with that we have this liquidated damage provision with terminated employees, at least by the statute. Then we get to the problem. If we go to the next slide, and you'll see here, we have an administrative rule, though, that says that, in fact, any violation of the West Virginia Wage Payment Collection Act could be the basis for a liquidated damage award, and that's what 2554 is. That the penalty under 2154E is the liquidated damage provision. So we've got a conflict here. We've got a statute that only deals with liquidated damages in the termination setting. We've got then a regulation that says, no, you can get liquidated damages for any violation. And that's why when we bring this up with how you're going to handle regular pay, it's important because you want to see what your possible exposure is. We've got a case in 2012, the Atchison case decided by Judge Chambers. And what he says, he looked at that regulation, looked at the statute. In that case, what you had is you had an employer who was paying once a month. And that employer was paying clearly in violation of 2153. Wasn't paying on a biweekly basis, paying once a month. The question is, what type of remedies could the employee obtain in that? One, asked for liquidated damages, said, look, here's this administrative regulation. And in West Virginia, this is a legislative rule. It's a little bit more than just an interpretive rule by the agency. It goes through the legislature, goes through the legislative rulemaking committee. So there's some past cases out there in West Virginia law that says, hey, this is almost the same thing as having the legislature decide it. Well, he looked at that and said, well, but basically in the last 3 or 4 years, we decided a case, the court decided a case in the antitrust context. And what they said there is that no, legislative rules aren't the same thing. They may have the force and effect of law, but they're not the same thing as legislation. And to the extent there's a direct conflict between an administrative rule or regulation and the legislation, then the statute controls, the administrative regulation is void to the extent it's in conflict. And what he says, hey, 2154 says in the termination context, the administrative rule, the legislative rule here is void to the extent it says any type of violation of the regulations, which would be the failure to pay on time every biweekly, that doesn't control, there's no liquidated damages. What then he looked at, and it's even more important, is he said, well, is there any claim here? And he looked at 2156, which is basically a provision that says if you're not being paid biweekly, you have to make a demand on your employer and request to be paid. And if your employer doesn't do anything in 5 days, then you've got a claim for legal interest on what you aren't paid. But if you don't make that demand, and he kind of added a little bit of a gloss there and said, well, maybe if the employer shows it's not going to comply, such as said, we don't, they held a meeting and said, we don't care about the Wage Payment Collection Act, you can do whatever you want. Well, maybe I'll also say that would be a refusal, as the statute says, to comply with the act. So he said, there's no claim here, employee didn't make a demand, and the employee's been terminated. By the time he was terminated, all the wages were paid. So there's no unpaid wages, so there's no claim. So that's one of the good things about West Virginia. The question he always still has is, it's a federal court judge. It's a good case, the Kessel case under the West Virginia Supreme Court, but there's another case where the court before, and we'll talk about it in a minute, had basically said, yeah, the legislative rule's in conflict with the statute, but we like the legislative rule. We think it makes a heck of a lot more sense than the statute, so we're going to enforce the legislative rule. So you're never 100% sure what the court might do. But you start that, and what you're going to do, you recognize this, that the 2-week provision isn't as, that the damages that you might have may be somewhat limited when you look at what you're going to do with this 5-day holdback. Then we get to the FLSA issue. And where we get there is this question as overtime compensation. Is that basically something that you can make a claim for? Because again, the main provision where we started down this road is how are you going to get your overtime in up to and including the 5th day from your payroll? That's the problem. And basically what we have at West Virginia law is, and well, let me start, what you have at the FLSA is that under 29 U.S.C. 218 is that you can have a more generous state law with regard to minimum wages. And as in the 4 states we have, Ohio's at $7.85 per hour. Obviously, the FLSA is $7.25. So Ohio provides a more generous minimum wage. They're going to go up 10 cents in January 1st to $7.95. All the other states are at $7.25. So you can have that. You can have also a more beneficial work week provision, such as instead of 40 hours a week you get overtime, a state could say 35 hours. Or a state can say after 8 hours you get overtime. So it's not that state law is somehow preempted in the sense that it cannot be there. But what it has to be is generally the same or more generous with regard to employees. What you have then is that you've got kind of two types of fair labor, well, I'll say is Little Fair Labor Standards Act, where states have these where basically they kind of mirror federal law with regard to payment of minimum wages and payment of overtime. The first type is what you really have in Ohio, Kentucky, and Pennsylvania now, and basically it's basically just a separate independent statute. Generally, it enforces the same types of things with regard to minimum wage and overtime pay, but it's independent of the FLSA. What you have in West Virginia is you have a statute that's not independent. In fact, you almost have a stopgap statute in West Virginia, because what is there is that you've got the definition of employer is that if you actually employ 80% of individuals who are subject to a law, and I think we basically probably have it up here on this PowerPoint now, if they're subject to a law relating to minimum wage, maximum hours, and overtime compensation, then they're not basically covered by the state law. So that means that the only remedy that they can then have is a remedy under the Fair Labor Standards Act if they're not paid time and a half over 40, or if they claim somehow that there was 15 minutes here, an hour there, they weren't paid when they should have. And overtime pay is obviously a great amount of the kind of cases you have under Wage Payment Collection Acts. So unlike Ohio, unlike Kentucky, unlike Pennsylvania, the only statute that employees in West Virginia can use is the Fair Labor Standards Act with regard to recover overtime compensation. And what you have here is that our courts have said, we've got the Hampton Inn case, we've got the Kendall case, and then there's a Fourth Circuit Anderson case, is that the FLSA provides the exclusive remedies for its own violation. And those remedies are obviously different than state law. With liquidated damages, they're different in the sense of it's double damages at most, instead of 3 times the unpaid amount under state law. The liquidated damage provision under state law is a strict liability standard. Basically the only one of all these states and in federal law. If you violate the statute, then you're responsible for liquidated damages. There's no scienter requirement, there's no excuse, mistake, whatever. You're liable. Under the Fair Labor Standards Act, there's a good faith provision that you can show, the employer can show, rebut the violation and rebut a claim of liquidated damages if they can show I acted in good faith and I had reasonable grounds to believe that I wasn't violating the act. Don't have that in West Virginia. So basically what our courts have said, the only way you can enforce a claim is through the FLSA. Therefore, you can't use the Wage Payment Collection Act because its remedies are preempted. Now, you have other cases out there and outside of the Fourth Circuit that have said, well, we think Section 218 allows alternative remedies. It's not just more generous provisions with regard to minimum wage or maximum hours, but you can have other remedies. And the problem we have, and this goes back to the 80s, when we first had cases under the FLSA and the state law, is people would bring the same claim, ask for, say, overtime wages, and a court would say, okay, you violated both statutes, we're going to give you liquidated damages for both statutes because we're going to say that the FLSA is attempting to basically regulate something different, separate and distinct from state law. It's regulating overtime wages. State law is regulating the prompt payment of wages. Back then, liquidated damages was 30 days of employment, not 3 times the unpaid amount. But this idea now, if you had that, you're going to get 3 times the unpaid amount at state law, You can get double damages under federal law. I mean, I think it's a double jeopardy problem. I understand that it's, that probably from a constitutional standpoint, nobody's going to agree with that, but it doesn't seem right. So I think what the Fourth Circuit has done in these cases, particularly where you don't have any state substantive basis, is important. And that's why I get to that is that in this 5-day requirement is, I don't believe that under state law, you could, since you cannot make a claim for overtime wages, my belief is the 5-day holdback provision doesn't apply to overtime wages. And you go back to federal law and the FLSA and the idea that you pay it basically at the regular payday or when it can be calculated. Therefore, I think if you have a policy that would be articulated to your employees, and again, it would be based on some type of rational basis about, you know, when you can calculate overtime, that you can go past the 5 days. Having said that, generally I'm relying on federal cases. You may have to litigate this in state court, and you never know what a state court judge is going to do with it. But I think there's an argument there, a good argument, and I think the other thing is the idea of what type of damages you might recover when you're dealing with regard to active employees is different. I will still say that when you're going to deal in the termination setting, you're better off to try to get all overtime paid within the Wage Payment Collection Act time limits that we'll talk about in a minute. But that's just one issue with regard to holdback. I think you can go more than the 5 days with regard solely to overtime wages. There's still an issue out there. The next one is the direct deposit. We've talked about this a minute ago. This again just shows that you have to have an agreement from the employee. Kentucky says you can do it mandatory. It's very clear. You don't need any agreement to do direct deposit. Obviously, you can't have any charge to the employee by doing it from a bank. Ohio doesn't have any laws that I'm aware of on it, so it's kind of up in the air whether you can require it from a mandatory standpoint. Pennsylvania is like West Virginia. It requires some type of agreement before you can do it from a mandatory standpoint, direct deposit. But obviously that's an important issue, you know, creating all the paper, mailing that to all remote job sites is an expensive type thing. I know employers are not happy about it in West Virginia, that it's not mandatory. If we move on then, with regard to, and let's go first now to Kentucky, and we'll come back to West Virginia in a minute. Okay, I've got plenty of time. With Kentucky, let's just deal with the time for payment of active employees. Now, I think I briefly covered this. Again, 15 days. Payment is that basically, or bi-monthly, obviously this could be 16. So you've got a semi-monthly requirement there with regard to payment of employees, but you have really the longest holdback, 18 days, that you can hold back and then basically calculate wages 18 days back. The other thing you have is that with regard to this payment, the timing of the payment, it does not govern basically those exempt employees, bona fide administrative, professional, executive, and I think it even throws in supervisory employees, also outside salespersons and what they call an outside collector. So those aren't even covered by basically this frequency of wage payment. Now, with Kentucky, I mentioned if we go to the next one, there's the Labor Cabinet has basically, through their Office of Workplace Standards, has questions and answers. One of them with regard to direct deposit says very clearly that the employer can require direct deposit so long as you have the ability to withdraw it without having to pay a fee to the financial institution where it is. So Kentucky, like most things, is a lot better than West Virginia with regard to the law they have. We'll go now to the remedies. We talked about them briefly in connection with West Virginia with regard to an active employee. We'll talk about them in Kentucky because Kentucky's remedies basically are the same. Whether it's the payment, the failure to pay an active employee on time, or it's the failure to pay an employee who's been terminated. And again, the usual types of things, all wages due and owing, attorney's fees, costs, The other thing is liquidated damages. No strict liability standard that you have in West Virginia, basically the same standard that you have under the Fair Labor Standards Act, the good faith type standard. Again, the employer bears the burden of proof on establishing it. We'll see that Ohio and Pennsylvania probably have the best standards for employers on liquidated damages, but still a lot better standard than you have in West Virginia. And then also says that, you can't have an agreement basically to pay less than the applicable wage rate. And we'll see some of these statutes, West Virginia particularly, and it kind of comes up a lot, has a statutory provision is that you can't waive any of these statutory rights. And any private agreement that attempts to waive any right, such as the time when payments due, is going to be void. Pennsylvania has a similar type of statutory provision that says that none of the statutory rights can be waived. One of the issues, I also want to cover it briefly, just because I think it's kind of important so you understand now, a lot of the wage litigation in the last few years has turned to class actions. I mean, in our state, we see a lot of it, certainly see a lot of it nationwide. And what you have, and why this kind of this issue about the Fair Labor Standards Act and state law is important, is what you have is this hybrid state law FLSA action. And why they want to have it is that the FLSA, not only with regard to remedies are different, as we mentioned, double damages, certainly with regard to timing, if you look at it, an FLSA claim you have to bring within 2 years. If it's a willful violation, it can be 3 years. Most of the Wage Payment Collections Acts are longer. Kentucky's 5 years. West Virginia's 5 years. Pennsylvania's 3 years. So most of those provide a longer limitations period. You also have the issue about class actions. In the 1930s when we had, or probably the 1940s, when basically the Supreme Court kind of opened up the FLSA to any kind of pay with regard to any type, when you stepped on the job site, you started to get paid. And basically we had this huge rush of lawsuits. Within a year period, there was in the federal system like 1,000 to 2,000 new suits. Congress stepped in and made the Portal to Portal Act that kind of, started to regulate them. One thing Congress did with that is basically change how class actions were done. And on the FLSA, a class action is an opt-in class action, which means that once somebody files suit, the employee doesn't get in the suit till he files a written consent. He or she files a written consent. And what really the statute of limitations isn't even told on that employee. Even once the suit's filed as a collective action under the Fair Labor Standards Act, it's not told until that time. Under state law, basically the Federal Rules of Civil Procedure and most of the other state laws, including West Virginia, it's an opt-out. And what an opt-out means is that you actually, when you get a notice, you actually have to send in and say, I don't want to be part of this lawsuit. And what that means is, why they want this state lawsuit is they're going to get a heck of a lot more people with regard to plaintiffs. And that's going to be larger damages, larger attorney's fees. There was one study done that said, where you have an opt-in, they think that the statistics showed between 15 to 30% of the employees actually opted in. It's a heck of a lot less than 100%. So if you start adding large numbers together, you can see how important it is to have an opt-out state class action there. So there's been a lot of litigation on this. That's why in West Virginia is the one good thing. You have the argument, at least with regard to overtime pay. Certainly you can have other issues like minimum wages where it can be different, or with regard to just some type of general failure to pay, you might have difference. But, in Kentucky, Ohio, we see large class actions. We see courts allowing them. In Kentucky, there was a decision out in the last 2 weeks that said, no, state class action and a federal class action are not incompatible. You can both go through. And basically, I think those courts are going to allow and have allowed, basically whatever damages you can get under both statutes. So, I mean, this is this class action area, and I'll make a couple suggestions at the end for it. what you might want to look at is a real problem. And it's still a problem even under West Virginia law. If you've got an employer who's not complying with certain provisions with terminating employees, and you got one plaintiff there, and they say, hey, I'm going to bring class on everyone else, including this one employee, and you're going to be involved in a large-scale case. So if we move on then with regard to Ohio, and we get to the payment of wages, we're dealing again, which I mentioned before, the Ohio Prompt Payment Act. And again, what you got is basically a full payday holdback here. Is that again, semi-monthly pay, and then you really have a fair amount of time then to calculate whatever wages are due and owing. Even as you can see at the bottom, there's even a provision that by custom, by agreement, you might even have a longer period of time that you can do maybe monthly pay. So again, Ohio a lot better than West Virginia, probably similar to Kentucky. Then we'll go on to the Ohio, as I mentioned to you, no law really, specific law on direct deposit. Certain people saying they think because of that you can require it. Some people saying it's an open issue, but there's no specific law there dealing with it. And then the liquidated damages provision of Ohio law, and it has some similarities to Pennsylvania law. And one thing I need to say, Ohio is one of the only states that does not have a separate Wage Payment Collection Act. So what you have under Ohio law, and again, you have basically one remedy, whether you're not paid as a regular employee or whether you're not paid as a terminated employee. And again, it's fairly liberal for the employer because it's only after 30 days of being unpaid. And again, you already have this holdback period. You got to wait 30 days. And again, that's if it's subject to a regular payday. If not, it's 60 days. If you have that, then you have liquidated damages. But what liquidated damages are is it's either 6% of the unpaid amount or $200, whichever is greater. The biggest problem with that is if there's a dispute, you don't get liquidated damages. All there has to be is the employer is disputing. Now, the Sixth Circuit has said in one case, yeah, it says dispute. We think you can, what I would call, do a soft look at it and say, if the employer really said we owe this money and then they just went to litigation 3 days later and said, no, maybe we're going to say that that's not a dispute. But it's clear from the cases it's a real soft looked at dispute. If the employer has anything to say, you're not going to get liquidated damages under Ohio law. So as I said, this really, from an employee standpoint, there's not a whole lot of teeth with regard to the liquidated damage provision. Again, you can recover unpaid wages, but in the Ohio Prompt Pay Act, there's no attorney's fees or costs. Go to Pennsylvania with regard to the payment of active employees. Again, it's kind of interesting. You've got a 1913 statute that says that basically, again, bi-monthly pay does say that you might have a different time period if you basically stipulated during the contract of hire to some longer period of time. Then we have the Pennsylvania Wage Payment Collection Act that was enacted in 1971 that talks about not the actual time of payment, but basically the holdback and what needs to be paid. And again, as you can see from the holdback provision, you can have it by agreement. If you don't have it specified a certain time, 15 days. Again, there's an explicit mention of overtime wages. Can be payable at the next succeeding payday. Again, gives you some time to calculate those wages. So again, a lot more lenient towards an employer than we see, particularly in West Virginia. Get to direct deposit. The statute's kind of a convoluted one that even provides for some type of written request by the employee. Then a written agreement needs to set forth the terms and conditions. So like West Virginia, again, an explicit requirement for a written agreement before you can do direct deposit. As we go on, the remedies for unpaid wages, again, unpaid wages, Under Pennsylvania, you have cost and attorney, reasonable attorney's fees. Liquidated damages, a lot like Ohio, a little bit higher and a little bit more teeth in the sense of instead of 6%, it's 25% of the total amount unpaid. Instead of $200, it's $500. Again, 25% of the amount of unpaid wages or $500, whichever is greater. Still not probably a large amount. The one thing it does say with regard to instead of a dispute, and just using that terminology, it talks about a good faith dispute. So again, I think basically there's a little bit higher standard for an employer to meet. I mean, I think it's near impossible in Ohio. Never saw any liquidated damages cases. I'm probably sure there is. At least the good faith concept that we see in the Fair Labor Standards Act comes in, but I don't think it's still to the level of Kentucky. So again, that's for active employees. Let's turn to terminated employees. And when we look at West Virginia law, again, when we start dealing with terminated employees with the most stringent standard from an employer standpoint. Up to this summer, it was basically you had to pay discharged employees within 72 hours of their termination. The West Virginia legislature, again, somewhat of a hue and cry of the business community saying that's not enough time because it's not just wages you need to pay here. You also have to pay accrued fringe benefits that are capable of calculation and directly payable to the employee, which can mean vacation pay to the extent that you have earned vacation pay that's due at termination, sick leave, whatever other type of fringe benefits that you may be paid, that all has to be paid within this 72-hour period, or at least up to last summer. The change that was made is a mixed bag. I mean, it helps some and obviously shortens the period in some cases. It's basically now 4 business days, and when they talk about business, doesn't matter if you operate all 7 days, business days are weekdays, not holidays, not weekends. So it's either that you pay them within 4 business days or the next regular pay period, whatever occurs first. So again, if you're near the end of the pay period, a day or two before, you might have 24 or 48 hours to pay instead of the 72 you used to have. I will say this, it's always been my recommendation, particularly when we were under 72, and it's, I think, generally throughout the bar here, if you're going to discharge an employee, you want to have that check there to pay him when you discharge him. You don't want to have any issues because there's no provision about how you have to get to them. You basically have to get the darn check to a discharged employee within their hands in 72 hours. And the best place to give it within their hands is to hand it to them there at the termination meeting. And even if you have to, suspend them pending an investigation while you get the check together, better off doing that. Clearly in this case, if you're near the end of the pay period still, have 24 to 48 hours, you're not going to want to discharge an employee and then, try to get it all together and make sure you get the check to them within the time period. You're going to want to have the check there to hand to them at the termination meeting. If you just passed the pay period, you got 13 days, maybe a different matter with regard to mailing it to them. I'd be careful about, the problem you have is if you mail to them certified, and they don't go and pick it up, then, there's a question as to whether, you complied with it. You didn't get them in their hands. You actually don't have anything back showing that they got the darn thing. So you have that issue there. The problem we have in West Virginia, because we have such a stringent requirements, is a cottage industry of attorneys have kind of grown up in the last 10 years, not as much work. So they've said, hey, these wage payment collection acts are great. All I have to show is that a day late they were paid, and I've got a guaranteed recovery of X dollars, and I'm entitled to attorney's fees. So it's a great case. There's a no-lose, there's no way I can lose. And generally, if you haven't paid in time, there is no way you can lose. They're right. So you've got them. They're aware of it. You don't pay somebody, the likely result is you're going to get a lawsuit. Every week you can open up our state legal journal and see 2 to 3 cases at least, maybe more, that are brought solely because people weren't paid, discharged employees weren't paid on time. So again, it's something you got to be concerned about. As I said, even though overtime may not be covered, I still think you need to do whatever you can do to ascertain it with regard to a terminated employee and get it paid. Because you'll have people out there filing suits if you don't pay it within the time period provided in the statute. And, you're not going to get your fees back even if you win the case after it's all done and over. So you want to stop that type of suit before it ever gets filed and pay whatever wages, are due and owing under your policies. If you have an employee who's quit or who is laid off, those employees can be paid at the next regular payday. Again, depends when. Certainly, again, it depends when they quit or laid off with regard to how much time you have, but you have that provision there separate and apart. Now, if somebody would give you a notice of more than 1 week's pay that they're going to quit, then you have to pay them on the day they quit. And again, liquidated damages can come in with regard to those individuals. I've got this, it's probably in the wrong place, but I'll just briefly cover it, because all these laws have provisions, even when you hire the individuals, that you got to notify them of their pay rate, you've got to notify them how their fringe benefits are calculated. West Virginia has, I think, even a little bit greater law, and let's talk about it for a minute, because you can see where it can come up in these other states too, is that it's not just before you do it. If you're going to make a change with regard to how their wages are calculated or fringe benefits, it's not just 2 days before. You've got to give them notice at least 1 full pay period in advance prior to making that change. So you've got to, and let's take an example with vacation pay. Let's say that you want to start a policy where people are going to, let's do the terminations provision. Last year you got to count, you basically started vacation from January 1st to December 31st. You run it as a calendar year. So you say this year we've allowed people to, we're going to pay their terminated employees who've been terminated, whatever vacation they still have due and owing. We want to change to a policy where we're not going to pay that anymore. So you're not going to get any unused vacation pay benefits paid to you at termination. Well, if you're going to start that and you're on a calendar year provision, you're going to at least need to do it 1 pay period in advance of January 1. If you don't do it 1 pay period in advance, somebody's going to claim it's not effective for the next calendar year, and they get those benefits. You're better off any significant pay period changes giving as much notice as you can, and I'll give you an Ohio case, which is, I think, would be followed in West Virginia. In this case, it's an Ohio Court of Appeals case. Individual, the company basically had paid, they said you could basically use vacation pay benefits that you earn this year or next year. That in November of a year, they said, we're going to stop that. Next year, you're not going to be able to use vacation pay benefits from the last year. So basically in November of a year, they adopted what I will call a use it or lose it policy. And so then the employee continues to work, this individual, works and then is terminated the next year, says, hey, I'm entitled to 20 days of vacation that I didn't use last year. Employer said, no, heck, in November, we told you you're losing those vacation pay benefits. Now in this case, the Ohio Court of Appeals said, employer, you lose, and the basis for them losing is they never submitted the revision into the record. And one important thing is, any types of things you do, any changes in policies, you want to keep it. I don't know why they didn't submit it into the record, and they just said it's a failure of proof, the appeals court. But you want to have it. You want to have it dated if basically when you gave it. Certainly you want to have, to the extent you're going to have a change like that, you want to have employees signing it. You'd rather even have the signature, have the policy attached. I mean, here I think they did submit the signature from the revision that he received it, but they didn't have the policy. It was just, hey, I signed this policy. But then the court went on and said, okay, even if we believe you and you did this, you know, this individual had accrued those benefits by November. You didn't tell him in November when this policy revision, hey, if you don't use those vacation pay or those vacation days in the next year, you're going to lose them entirely. And they said, you know, we don't think you can do that. You can do it prospectively and say, starting next year, you got to use it within a year, but we're not going to use that retrospectively and allow you to take away those accrued benefits at the end of the year. And I think the exact same thing would happen in West Virginia. So if you're going to make modifications to the policy, I mean, are you taking away something that somebody has today? And if you're taking it away, it's likely that it's not going to happen. Now, maybe if they had said it back in March, okay, you got to really use your vacation this year. Probably wouldn't work under West Virginia because somebody's going to argue you needed to give that one pay period in advance of the beginning of the year. But, I mean, just remember that even in these other states that modifications can be tricky. Now, generally under modifications, and I think this would apply in all these states, is that it's kind of a unilateral contract because these are by employment policies you have, and courts, even West Virginia court will say that you can revise them by just issuing a new policy, again, complying with the timing requirements, and basically the employee accepts that by continuing to work. Because most of these times you don't have a written agreement, it's the employment policies that create the obligation. And you'll have just a boatload of cases out there, more outside of West Virginia, in Ohio, Kentucky, even Pennsylvania, where people say, hey, I know the policy was in there, my employee handbook, but hey, there on page 1, there's this prominent disclaimer that tells these individuals that you don't have any rights in my contract, in this contract. You're an at-will employee. So basically, this handbook doesn't say it create anything. It's just gibberish, guidelines, whatever. Well, courts with regard to, well, they'll enforce that with regard to employment at will. They're never going to enforce that in the fringe benefit area. They're going to say, even if we say that you didn't create some type of contractual employment relationship, we're going to find it enforceable. Generally, they'll find it enforceable because all these laws say you got to tell the employees at the beginning of employment how you're going to pay them, what their wage weight is, how you're going to calculate these fringe benefits. That's what you've done. I mean, West Virginia, to really have an enforceable disclaimer, we've got the Williams v. Precision Coil case. You basically have to tell people that, you know, this handbook doesn't provide you with any rights. So, I mean, it goes about as far as the disclaimer you have to go, but even still, they're going to say, you need to tell them what their fringe benefits are, and because it's there in your employee handbook, we're going to find a binding contractual obligation for what you put in there. Let's go and then talk about fringe benefits. I mean, we started getting this area about how do you calculate them. And the law changed with regard to West Virginia, or basically was made as clear, maybe as clear as mud, but still was somewhat clarified back in the Meadows case. And prior to that, there was this question as, can you ever basically have a fringe benefit that you condition, say, that you're not going to have any, that you're not going to pay unused portions of the fringe benefit upon termination, basically a forfeiture clause. And there was a lot of discussion, particularly with regard to vacation pay, that no, we don't think anybody's ever going to say that. There was a fair amount of states out there that said you couldn't do it, some that said you could. One of the problems is if you look at the labor law area and the development of vacation pay in it, arbitrators, even courts have kind of said, you know, vacation pay is used for additional compensation. It's deferred compensation. So again, courts and arbitrators in the labor collective bargaining agreement context are really leery of cutting people's rights to vacation pay off. And that was one of the reasons why we thought it would be difficult, even though when we have basically this idea of accrued fringe benefits that are capable of calculation and payable directly to the employee, it said that, that we're not going to, that you can have an agreement, and this statute's not going to trump an agreement you have with regard to calculating fringe benefits unless it's in violation of the Act. So you had that, so there was a real question there. Meadows did say that it's up to the employer, basically, to promulgate policies, and those policies it promulgates is what's going to create the obligation or create the entitlement to benefits. Wage Payment and Collection Act, as I said to you when we started the seminar, in none of these states, including West Virginia, provides any substantive rights, any substantive entitlements to fringe benefits. Court said you do it through employment policies. So we start with that. Then the court went on and said the employment policy is going to determine what's accrued or what's a vested benefit. And in most of the states, Kentucky relies on this kind of vested benefit concept. So we're going to look at the employment policy decided. Court also said, you can have a policy as long as it's explicit that basically employees are not going to be entitled to unused fringe benefits at termination. Has to be very explicit in the policy. The second thing, obviously, you can have eligibility requirements other than just performing services that would have the accrual, that would provide for the accrual of fringe benefits. And, and I'll use a term. I mean, there's a couple terms. I don't know how well they're accepted in the HR. They occasionally show up in these cases. There's kind of what we'll call the pop-up policy. And what that means is on a particular day, a lot of times the anniversary day for an employee, sometimes December 31st, on that day, solely because they're employed on that day, they'll get all their vacation benefits for the entire year. So December 30th, they have nothing. December 31st, they may have 2 weeks, 3 weeks, whatever. And that's why it's called pop-up. I'm not saying it's an HR term, but you'll see it occasionally in the court cases. That's an eligibility criteria that basically in Meadows the court was saying we're going to enforce. You also have, and I think I might have, you've got this pay-as-you-go policy, or earn-as-you-go policy. And what that is that you're earning your vacation in the year that you're taking it. So what will happen with those policies, and basically prior to 1999, our Division of Labor said you can't forfeit a benefit, and no matter what you say with regard to vesting, we're going to say you're always earning vacation for the next year. So we would always suggest to employers, adopt an earn-as-you-go policy. Basically then, you're not going to be on January 2nd of the year, you're not going to have 10 days, they're only going to have a day at most. July 1st, you're going to have 5 days earned of vacation. So if you're basically going to have to pay that, if the Division of Labor would prevail or you're not wanting to fool around with the darn case and spend that money, you're going to have less days. The earn-as-you-go policy, the one negative thing of it is that you're generally actually giving folks vacation that they haven't earned in advance of earning it. And the problem is they may show, tomorrow they may quit and they've taken 7 days of vacation when they've only earned 2. So you have the issue of what you do with that we'll talk about, but there'll still be, people will use the earn-as-you-go policy still. My belief is the policy you need to have is basically you don't get any unused vacation pay benefits upon termination. And the reason for it, there's 2 reasons. The first reason is, you got so little time to pay discharged employees everything they're doing owing, you don't want to be fooling around with vacation pay benefits. The second reason is the other part of Meadows that said, we're going to give you this sweet part that you're the one who's going to be able to determine what the rights are, but we're going to give you a bitter pill too with that, is that if you have an ambiguous policy, we're going to construe that ambiguous policy against you. And what they later said in the Tucker case is that, large employers who have these employment handbooks, they can hire competent and intelligent attorneys with full use of Queen's English and their subtle knowledge of the nuances of employment law, and you can have teams of lawyers can determine that the policies are clear. Like that ever happens, but I mean, they wax on eloquently about rooms full of lawyers who are going to be dealing with a vacation pay policy to make sure that a large employer has one. What the funny thing was is the Tucker County case was the Tucker County Commission. It was a small governmental agency who probably couldn't hire an attorney. And they even say that eventually after they wax on eloquently about large employers and say, well, yeah, we know you probably can't hire anybody, but heck, you're an employer too. So we're going to apply the same rule to you, and if you have a darn ambiguous policy, we're going to construe it against you. Now, and just so you kind of have a framework for the law, because it's kind of depends, and I'll kind of use Ohio law in a minute to show the difference. I mean, there is a common law contract idea that we're going to construe as a rule of construction that at the end of the day, if we can't figure out what a contract means, we're going to eventually construe it against the drafter of the contract. And if there's two reasonable meanings there, one where the guy who didn't draft it can argue, one the person who did draft it can argue, at the end of the day, we're going to give it to the person who didn't draft the contract. But that's a rule of construction, which is the last thing. It's kind of the tiebreaker, the flip of the coin, if you're dealing with regard to sports. And finally, we've done everything we can, so we got to decide who's going to get in the playoffs. That's what we're going to do if you're not going to play a game. I mean, that's what it is in common law contract. We're going to allow parole evidence in first, let the parties testify as to what the negotiations were. We're going to use rules of interpretation, which basically have been conducted to look at the language and try to ascertain the meaning of what the parties wanted. We're not going to look at a rule of construction which is only concerned with the legal effect. We don't care what the parties intended. But what we've done in the Meadows case is we're going to say that's the primary rule, that the first thing you look at is who drafted it. Obviously, it's the employer. And you lose. There's nothing else you can do. We're not going to let you put in parole evidence. Poor Tucker County Commission wanted to put in parole evidence and say, hey, this is a longevity pay. This person wasn't entitled to it. And we said, no, you're an employer. You don't get to do that here. Doesn't matter that you're not a big boy. Doesn't matter you couldn't have a lawyer. You don't get it. You lose. And that's the bad part of the Meadows case. If you have anything ambiguous, and if we, let's go to the Meadows case, the slide for it, and I'll give you an example. Because of this rule of ambiguity, you don't want to open up the possibility that somebody can get vacation pay benefits, or get them in a way that you basically not defined. And I'll use the Kmart case. The Meadows case actually was 5 cases consolidated together. And the court ruled on each of them. Kmart was in one of them. Kmart had a vacation pay policy. The court found ambiguous. And what Kmart's policy was is that they had first that you had to be there a year to get any vacation. And that's provided in the policy, and the court said, that's clear. We agree. No ambiguity there. Those people weren't employed for a year. They don't get any vacation. The problem started after a year. What happened is at a year to 2 years, you get 5 days. And now, what do we do then when an employee, after getting that 5 days, a month later gets terminated? Well, what Kmart had in their policy is they obviously have the entitlement, and some management folks testify, after that year, they get those 5 days of vacation to use. But if suddenly they quit after a month, then what the policy says is that will be paid 1/12 of their current year vacation due for each month of service completed during the fiscal year. I mean, one thing, that the court never really talked about it because they were always taught, the testimony was anniversary year. Don't know where fiscal year came in on the policy when you look at it. But here was the problem that the court said. I mean, kind of this is a pop-up policy. 1 year service, you hit that, you get your 5 days. You were going to determine vacation on the anniversary date. But then what we're going to go is, we're going to go to what I would would characterize almost as an earn-as-you-go policy with regard to termination, because you have these 5 days. So what their testimony was, yeah, we know we gave you 5 days, but if you only worked a month more, you got basically 1/12 of 5 days. You didn't get 5 days and something else. And what the court said is, you're not really saying what happens to the 5 days. If you said they'd forfeit them if they didn't use it, then we might say, okay, they just get 1/12 of 5 days. But how the court viewed this policy is ambiguous, and I'm not sure it is. I think I can understand it, but what they said is, what you're really saying here is you get 5 days when you get to your first anniversary, and then you start earning new vacation, kind of like the DOL always said, for the next year. Now, maybe you can't use it, and maybe as earn as you go is probably not right because you can't use it. There's another term, it's earn in arrears, which basically that you're earning it for next year, can't use it now, but still if something happens, it's a vested right. And that's what they said. They said, you're not just you're getting 1/12 of 5 days if you quit a month in, you're actually getting 5 days plus 1/12 of 5 days. And so what I'm trying to say is that my view of vacation policies are they're so difficult to craft, particularly once you start talking in fractional terms, that the idea that you're going to have some type of ambiguity is just, it's rampant there, no matter how many teams of lawyers you have in a room. So I think you're always better off. And all these other states, Ohio's pretty clear, if you have a provision that says that you forfeit the vacation, that you don't get the vacation when you're terminated, they'll enforce it. Kentucky clearly will enforce it, and I believe Pennsylvania will too with vacation pay. I think that's the way to do it. I wouldn't try to screw around and give somebody something because you're always going to be faced that you're going to choose wrong, you're going to have some ambiguous language, and you're going to have more, have a court say, you're giving more than you thought you were. There is a case I want to briefly talk about. It's the next one, the Robertson case. And this kind of says that, well, maybe even though we have this rule of ambiguity, there is a chance, and I use the bitter, you've got to take the bitter yet the sweet before, there's a chance that we're not going to let you define the policy. And what happened in Robertson is they had a policy that said, you as commission sales folks, you'll get so many days of vacation in a calendar year. And you can take those days, but you're not going to get paid for them. In fact, we're going to deduct your draw for those days you're on vacation. And lo and behold, next February 15th, the following year, we'll give you all that vacation pay back. And if for some reason, you've taken those 10 days, we deducted your pay, and you got terminated before February 15th, you don't get any vacation. So what the court said is, they never said, in looking at the policy, there was no ambiguity. The court explained it perfectly, but they didn't like it. From a substantive standpoint, they thought it was too much. So what they find the ambiguity is in the statute and said, well, it says accrued vacation. Well, an employee would believe he had accrued vacation if he was able to take a vacation day. Well, that's not the issue. The question is does the policy create a right? And the policy is pretty clear. You can take the days, but you don't get paid till February 15th. So there really wasn't any ambiguity in the policy. The word accrued was never used. But it's clear from a substantive standpoint, they didn't like it. And that's why they basically said, this goes too far. You've got to pay them on the day or the pay period that they basically took that vacation. So again, even though you have this right to create policies, there is going to be some type of rule of reason there. And I think the other states would find it. Briefly, let me kind of talk about Ohio in a case to show a little bit the difference that Ohio does to West Virginia, and probably then the difference that these other states would also adopt. There's a case within Ohio, and I think we can turn to the facts of it on page 27 of the, and what I want to say is that this was a weird case because the employee actually put together the pay package. And there became a dispute over it, She was a short-term employee. Actually, the employer, when they hired her, knew that she was pregnant. She was going to go on maternity leave. She came up with this policy. The employer made one simple change to it, basically, that she'd get a raise based on her performance. But in the policy, there was the idea that she would have 8 weeks of maternity leave and 2 weeks of vacation. And the question was, well, was that paid? The employer didn't pay it. The employer said, look, the policy says for holiday, paid company designated holidays. And there's this rule of interpretation that if you have one thing said there and then you have other items which doesn't have that same thing in it, basically maternity leave and vacation doesn't say paid, then that means we didn't intend it to be paid. So they argued that. The employee said, no, you got to look up at the top and say pay package. And based on that, all those categories, maternity leave, holidays, vacation, was all paid. And I just put designated paid holidays to show that those were the employer's holidays. Court said it's ambiguous. Either one could win. What did they then construe it against the employee immediately because it was ambiguous like West Virginia, although probably wouldn't in West Virginia on that case? No, they didn't. So they didn't follow that rule. They followed the contract rule and said, okay, let's take parole evidence. Let's let the parties testify as to the intent. And they found, yeah, the employee made it clear to the employer during the negotiations that she needed paid vacation, she needed paid maternity leave, so we're going to find that. But then there became an issue, look, but she terminated her employment without taking the vacation. And hey, it's silent there as to what happens with regard to when somebody gets terminated, whether they get paid their vacation pay benefits. Just says 2 weeks. And so the court said, well, the employee says with regard to parole evidence is that, well, we never discussed it, but my last employer, we did it that way. Court said, nah, that's not reasonable. I'm going to construe it now against her because there's no parole evidence and she doesn't get paid for vacation on termination. So what you have there, then eventually you do get to the, basically the contract drafter rule. And in West Virginia, I think the same result would happen for vacation pay, is that if you didn't specify what would happen in your policy, and that's why it's critical to specify, if they're going to lose it, they lose it. If you don't specify it, I think you're going to get it. Interestingly enough, one thing that happened in the wake of Meadows, Meadows said you could get it for sick pay. You could actually have a policy here that said you use these days for sickness, injury, and illness, and because you didn't specify in the darn policy that you lose it at termination, you've got to pay it. Well, who would ever expect to do that? Because the eligibility criteria was always sickness, illness, or injury. So what happened is for about 10 years, that was the law. Until 2011, they finally recognized what they'd done is wrong, and they said, yeah, we understand that this was a mistake. Nobody would believe that you'd get sickness pay. So if it's silent on sickness pay, you don't get it when you're terminated. One other thing they did to try to handle these cases in the meantime, they still didn't allow parole evidence in, but what they did say is if you have a consistently applied, unwritten policy that you never get, that you never pay benefits, and the employee, the plaintiff in the case knows that policy, he loses. He can't still claim it's ambiguous at the same time knowing you had a policy. So a fair amount of those cases were decided on that ground. We've got some other things on deductions. One other thing I want to mention, because I think it's really critical in West Virginia particularly, but I think you can find it in these other cases. You got to be accurate with regard to your pay stubs and pay information. Because what in West Virginia particularly we've seen is that if you have on a pay stub that you have you show how much vacation they have, how many leave days they have, and it's wrong. You as the employer is going to be bound by that. You're going to be stopped from saying it's wrong. So when the employee comes in and says, hey, my pay stub said 30 days, he gets 30 days because they're going to look and say, you've got an obligation to tell him what he has. You've got an obligation to make it accurate. So you've got to always look at whatever documents you're giving to your employees and make sure they're accurate. Sometimes this is an area of less is better than more. So you don't want to, the last thing in the world you ever want to give to somebody is some type of inaccurate policy. A couple of things I'll briefly talk about. I told you I was going to about what you could do with regard to this idea of hybrid class actions. Obviously, arbitration provisions. I mean, the United States Supreme Court's been pretty clear in the last few years that you can have a class action waiver in your arbitration provision. That's a way to eliminate these types of claims. Have these individuals go to arbitration, can't bring class actions. The National Labor Relations Board's tried to fight it. I think they've been unsuccessful in almost every court so far. That's one thing. Again, shorten statute of limitations. Kentucky particularly, there's a federal court case under the Kentucky wage law that says that you can have a shortened statute of limitations. So if you have it in an employment application, employment agreement, in Kentucky it was 6 months with regard to this Kentucky wage claim. The federal court enforced it. Normally, because there's no statute of limitations in the act, it's 5 years. So I think in those states, Kentucky, Ohio, probably Pennsylvania, although again, the statutory provision in Pennsylvania that says you can't waive any rights under the Wage Act may be an issue. But there are other cases in Pennsylvania that has enforced 6 months. Sometimes they've said a year. But in all those 3 states, you have very decent case law that said it. No case law in West Virginia. I don't believe for a second that our West Virginia court would enforce a shortened statute of limitations with an employee. I think they'd look at the Wage Payment Collection Act and say, says you can't waive rights, even though the statute of limitations doesn't appear within it. I think they'd say that. There is a recent Sixth Circuit case, Boaz, that said under the Fair Labor Standards Act from some 1940s cases, can't waive any rights. So they've said you couldn't waive the statute of limitations. So West Virginia would follow that. They'd also follow this idea. FedEx has been one of the big proponents of these statute of limitations, shortened statute of limitations. They have their employees fill out employment applications, sign employment agreements saying before they ever get hired that if they're hired, they're going to be subject to the 6-month statute of limitations. Our court would say there's no consideration for hiring, for basically signing an employment agreement before you're hired. The mere fact you're going to be considered for a job isn't enough. They're not going to enforce it. They haven't enforced arbitration policies that were signed that way. So, I mean, I think we've run out of time without probably covering half. But as I said, I'll have a much longer paper for you here within the next couple of weeks. Are there any questions? Okay? No questions. Well, I can take just a couple minutes on deductions, and let me do it from this aspect of wage assignments. It's critical, particularly in West Virginia, but in a lot of these other states too. If you have basically, obviously you have authorized deductions, which are taxes, union dues, can be health insurance, no problem there. But if you want to take some type of other deduction from pay, you're going to have to get a wage assignment. And let's deal with the earn-as-you-go vacation pay. The Fair Labor Standards Act, interestingly enough, talks about deductions. You'll see in the PowerPoint I have this, that they say if you tell an employee that, we're giving you this vacation, our policy says if you leave employment and you have unearned vacation that you've taken, the Fair Labor Standards Act will allow you to deduct it at the last check, even if it brings them below minimum wage, which is really the issue in the Fair Labor Standards Act. That's fine for the Fair Labor Standards Act, but if you have an earn-as-you-go policy, if you give people vacation in advance and you want to take it back when you terminate them, you need to get them to sign a wage assignment right at that point if you're going to do it. And, I've given you basically the criteria you need. You can only take up to 25% of the wages. You've got to follow religiously. Our court will say if the employer doesn't even sign it, they've got to sign the wage assignment, then it's not valid. It's only good for a year. You've got to provide the specific amount. So there's a lot of hoops you've got to go through to do that. So just remember that anytime you're going to take a deduction, if you mispaid somebody and paid them too much, you're only going to be able to get that back if you get them to sign a wage assignment. You can sue them for it, And, you know, there's some federal court cases that have said, yeah, you can go, if you make a mistake in fact, pay somebody more, you have a right against them. But you won't be able to take it back through a wage assignment, or you're going to have a violation of West Virginia law. So just be careful with that. The law in other states are maybe not quite as bad, but they still prohibit deductions quite a bit. Even in the theft area, there's an area in West Virginia as to whether if somebody commits theft and you fire them for that, whether you can deduct their last paycheck. There's a common law doctrine, it's the faithless servant doctrine that says you lose your wages during the time period that you were disloyal. You forfeit them as a matter of common law. And there's some 1920s cases out of West Virginia that says that. In the 90s, I prevailed in a motion to dismiss in federal court on that issue that eventually led to a settlement in the case. But who knows as to whether our state court's going to say that common law doctrine continues to be part of the Wage Payment Collection Act. I think it's an open issue. I think you have to be careful even there. The Fair Labor Standards Act will say that you can basically reduce wages such as for theft, if below the minimum wage, if the individuals confess to it or they've been convicted of a crime, one or the other. If they haven't, you cannot deduct such that you're deducting their wages below minimum wage. And what I mean is that, you know, if they work 30 hours, get $7.25 an hour, you know, around $250, you can't take all of it away from them because you think that they stole something where they haven't confessed to stealing. That would still be a violation of the Fair Labor Standards Act. Anything else? I think we're probably close. Yep, I think we're a little bit over. Thank you for your attention. As I said, I'll get out a paper. We'll get out the PowerPoint to you here in the next couple of weeks.
Okay, to exit the webinar, simply close your screen. Thank you.
Good job, Alex. Thank you.